beautiful afternoon. I think it will be worth your while. Am I mic'd?
Yes.
Good. So I want to get to this feast of presentations as quickly as possible, but I would be amiss if I didn't try to frame this a little bit, for today's discussion a little bit, in my personal perspective. When I started to do this stuff 50 years ago, a lot of what working copyright lawyers did, and a considerable amount of what copyright teachers taught, was about copyright formalities. When I was a student in a copyright class in law school, we spent more time in terms of class hours on the proper affixation of notice than we did on fair use, because it was a bigger issue. It was extremely consequential in terms of getting and keeping rights in ways that those who have grown up in a arguably more enlightened age are probably in no position now even to imagine. And the very first big case I ever did was a case that took me and my adversaries in the court into the sort of deep, dark heart of the renewal provisions of fragment memory. Formalities were a really big part of copyright law. And in the movement of the field over this half century which I've been involved, one of the most startling developments has been the de-emphasis on formalities, part of which is a matter of statute law, part of which is a matter of judge-made law, and part of which, of course, is a matter of professional convention. We simply don't talk about it as much because it doesn't matter as much. We've seen the notice formality reduced to a sort of pale shadow of its former self. We've seen renewal disappear, at least in a prospective sense, as a consideration altogether, and all that really remains in the domain of formalities is copyright registration. Now, among various kinds of speculating academics, the idea of the pros and cons of the reformalization of copyright law has recently reared its head, but that is, at least for now, so far, an academic discussion. And in the real world, we are the beneficiaries, perhaps is a good word, certainly the bearers of the consequences for good and ill of this radical de-emphasis on formalities that has occurred in the last half century. In fact, even with respect to registration. There have been some very, very close calls. In the mid-90s, for example, we came very, very close to enacting legislation which would have stripped away from the registration formality the most powerful incentives to timely compliance, that those that go, of course, to statutory damages or qualification for statutory damages and attorney's fees. We turned back from that moment, but we came extremely close. And now we are met here to talk about this morning's argument, which has joined the issue around another aspect of the registration formality, that is to say, its significance in terms of the initiation of infringement legislation. And here I have to apologize to former students who may or may not be in the room. I see a few of you, because for most of the years that I taught copyright law, I did it in complete innocence of the fact that the issue that we are here today to discuss, namely whether or not the prerequisite of registration for the commencement of infringement litigation means a completed registration or merely the completion of a registration application. For most of the time that I taught copyright law, I was completely unaware that an issue could be made, let alone would be made, around that question. So those of you who heard me talk about the registration formality in class, well, as I say, all I can do is apologize for not having had more foresight. Nevertheless, here we are. And we are poised to receive clarification from the Supreme Court about how the provisions in question should be read. We know, thanks to Muchnick, that there is, in fact, a requirement for pre-litigation registration, or more technically, a requirement for the registration or rejection of an application for registration as a prerequisite for suit. We know also from Muchnick that it's not a jurisdictional requirement, which I suppose is helpful, although whether it bears at all on what we have to talk about today, I'm less sure. But what we don't know, and what we may find out now, is literally what is meant when the statute refers to registration. Whether what is meant is the initiation of the registration process or the completion, for good or ill, positively or adversely, of that process. And that's what I would say, by way of framing the issue that we have now before us. And what I'd like to do is, before we go any farther, to introduce our panelists. And I think I'll start at the far end and give you then Rob Kasanick, the Associate Register for Registration at the Copyright Office. I will also, and now I'm going to go to my bios to make sure that I have an apt word or two to say about each. I want to present Elizabeth Brannon, who was the counsel for respondent, wallstreet.com, in this case, from the Strisson-Mayer intellectual property litigation practice. We have from Public Knowledge, Meredith Rose, whose organization filed an amicus brief in support of respondent. And we have Matt Williams, who is here because he was responsible for an amicus brief on behalf of the Copyright Alliance in support of petitioner. And then finally, we have a last-minute guest. Could you introduce yourself?
Joel Rothman, I'm counsel for petitioner, Fourth Estate.
Excellent. Thank you very much for coming. So, before I go further, who wants to extend or correct my characterization of the issue in the case?
Peter, could we let John say a word? The Copyright Society.
Thank you. I was going to introduce you, and I apologize. Here is John Riley. This is a very momentous day for this Supreme Court Intellectual Property Workshop Series here at the Washington College of Law, because for the first time, we are co-sponsoring one of these events in connection with the DC chapter of the Copyright Society of the United States, an organization with which I am pleased, I did the math last night, to have been associated for the last 37 years, almost as long as I've been associated with the Washington College of Law. we're extremely grateful and flattered, John, that the society has seen fit to join us, and very grateful to your work in support of this occasion. And the mic is yours.
And I will keep it very brief. We are very thrilled to be a co-sponsor as well. And I wanted to say specifically to Professor Jazzy, Professor Carroll, to William and Sarah at PIJIP who helped us organize this. Thank you very much. The Copyright Society, for those of you that don't know, is an educational society. It has the most copyright lawyers probably in any professional society. So if you're a student here and want to sign up, it's only $25. And I will plug that we will have our annual meeting in Baltimore this year, so it's a little easier for folks to go to if you're interested in going. And again, thrilled to be a co-sponsor here. We will also be a co-sponsor for next week's event, which I believe is on Monday. And I will also say we have another event, not at American, but at GW on February 12th. That's our annual Meyer lecture. And I hope to see you all there, and thank you for coming out. With that, I will turn it back over to you.
Thank you, John. These are all great events, both from a networking standpoint and from the standpoint of substance. And again, we're thrilled to be in partnership now with the society. So my question, who wants to briefly amend or correct my characterization of the issue before we get into the details? All right.
I'll amend the characterization.
All right, I like that.
Not of the issue, but just to say in terms of formalities, I think one thing that we've seen at the Copyright Office, and we recently did a workshop with the World Intellectual Property Organization, and there is, while formalities have been disfavored in many cases internationally, we're seeing a resurgence of interest in formalities, and in particular in registration. And there are many countries around the world that are beginning to create registration systems and electronic registration systems, of which the U.S. Copyright Office is also trying to create a modernized and re-envisioned electronic registration system. So I think that there are many positive, we're seeing positive shift now, putting aside exactly what the incentives are for those formalities, that there seems to be a sense around the world now and in the digital environment that there can be significant benefits to having a registration system.
And can you explain a little more about what that motive is, about what countries or copyright systems that are moving toward an invigoration of registration see as the benefit?
In many cases, I think it's just to have a public record of who is claiming what. The examination functions differ widely amongst countries, as do the deposit requirements. But in order to facilitate a public record and registry of authorship, and also to, in conjunction with that, having a recordation system and transfers of ownership, now that there is the ability to incorporate new kinds of identifiers, unique identifiers with works, with authors, with various kinds of owners of works, that this would be something that could facilitate lawful transactions in the digital environment as well.
Thank you. So then, here's a sort of a toss-up question, but we can just go down the table and get an initial response from anyone who wishes to give one. And I think Rob has made an interesting statement from the international and comparative point of view about why in the abstract a registration function may be important in copyright law. But that, of course, is not technically the issue in this case. The issue in this case is far narrower. Simply put, whether or not word registration in section 411A means a completed process or the initiation of a process. It seems really, and most people, including close friends to whom I've tried to describe the issues in this case, respond immediately by saying, well, that really seems like a kind of a hyper-technical point. Very interesting, I suppose, to a very few people, but hardly a matter of great moment. Obviously, the court takes this case, at least in part, because whether it's a matter of great moment or not, it is a matter that's relevant to the administration of justice and a matter about which we have now a significant division among the circuit courts of appeal. But putting those questions aside, who cares? Why does this matter? How are we spending a nice late winter, midwinter afternoon talking about it? Why are we spending significant resources debating it and resolving it in public? Please.
Well, I'll tell you from my perspective, I labor in the copyright mines every day. I've probably myself and the other members of my very small firm are the number 3 or the number 4 filers in terms of copyright infringement cases around the country. I mean, in terms of total cases over the last several years. And this issue matters tremendously. You know, in terms of the framing of the issue, please, it's not like the petitioners believe that formalities are not required, don't serve a purpose, and shouldn't exist. Of course they do. The formalities are very important for all the reasons that, you know, not to mention the addition to public knowledge, which is critical. It's really just a matter of timing. And what does registration, what does the act mean when it says has made registration? Is that an act that can be completed by the copyright owner, or is it an act that requires the participation of the Copyright Office? No one, I think, on the petitioner's side wants to take a penny of the money that the Copyright Office is entitled to out of its pocket, nor remove it from the system. It's critically important, and it's just a question of timing. So for my clients who I file cases for on a regular basis, the difference between being able to file a case, having paid the fee, submitted the deposit, submitted the application, versus having to wait and potentially lose rights, is highly significant in an era where the internet has become a place where most people believe that if they find it there, it's free to use. And of course, at least most people in this room should know that's not true. Not every court does, but so it's critically important.
So I have a perspective on this as well. Before joining Strisson Maher, I served for 3 years as the Director of Intellectual Property for Barnes & Noble, another company that is a stakeholder with respect to copyright. I'm still in touch with their general counsel, and when I described the case to him and the fact that our firm was representing the respondents, he asked me the same exact question: who cares? So I'm relieved that some people care, but I do think that this is certainly a question of statutory interpretation where Congress could have adopted either regime and the sky will not fall. The rule, once it's clear, will be generally possible to follow, whether a mere application is enough or whether a registration is required. We, of course, on behalf of the respondents, favor the view that the register must act, but I think there are a lot of people who might not think so closely and sort of say, yes, who does care? So I'm relieved that someone does.
Judge Pryor in the 11th Circuit really cared a lot. I'll tell you, I argued the case in the 11th. I didn't argue today. and my opposing counsel in the 11th isn't here today. But we were third on the docket. Judge Pryor's now the chief judge. I don't recall if he was the chief judge at the time. But we were third on the docket. There were two very big, weighty criminal appeals before us. And they called us with the last case third on the docket, and everybody who was there for the two big, weighty criminal appeals, got up to leave. And Judge Pryor stood up from the bench and said, "Wait, this is the best case. This is the most interesting case of the day. Don't leave." Seriously. He was, for anyone who, lives with statutory interpretation day in and day out, who believes that the laws on the books and the law created by case law really matters. This case is, a tremendous buffet of great, interesting, and just from the standpoint of English grammar, the idea that the Supreme Court would be wrestling over the passive voice and what does that mean in this context is I think it's significant. I'm glad I majored in English. Not because it hasn't helped me qualify to take the patent bar, but I'm glad for other reasons.
Yeah, I'll piggyback on that a little bit and say that legal writing professors should care about the case because it's a perfect example of why not to use the passive voice, because it always begs a question and the question has to be answered eventually. I attended this law school and graduated 13 years ago, and both Peter and Rob taught me copyright at different times, so very happy to be back. As Peter said, I did an amicus for the Copyright Alliance, and they care and their members care. It's a nonprofit organization that is the unified voice of the copyright community. It represents big copyright owners, small copyright owners, everything in between, individuals who would be harmed by requiring office action before a suit could be filed. In the arguments today, it was interesting. Judge Kavanaugh really asked the petitioners, what are the harms that you're talking about? And I don't think they laid all of them out. They didn't quite get the chance to do that, so I'll try to do a little of that. They did focus on the inability to get quick injunctive relief, and that's a real problem. If you've got digital piracy, for example, and you can't get a quick TRO, you can lose a lot of money very quickly. So that's a very important one. Also, with the DMCA notice and takedown provisions, you can get a takedown quickly by just sending a notice, but if a counter notice is served, you've only got 14 days to file a lawsuit or the stuff goes back up. So that's a really short period of time to get a complaint on file, and if you're waiting for your application to process, that's another burden you'd have to deal with. Another thing is that the statute of limitations can run, of course, before the application is granted and the certificate is issued. So that's a real problem. There are some cases we found where judges have reasonably said that there could be an equitable tolling that would forgive you that time period, which I think would be great, but there's no guarantee that every judge is going to do that. Evidence can be lost in the interim. People can die, witnesses can die, documents can be destroyed, etc., before any discovery kicks in while the application is pending. We did some research, and it appears at least that in some courts you could waive compulsory counterclaims because if in a DEC relief action, a declaratory judgment action, if the potential defendant sues you first and you don't have a registration yet and you don't get it processed before you have to file your answer, you could waive your compulsory counterclaims potentially. Of course, everyone knows there's an increased cost, and I've heard said that, well, even the expedited application is only $800 additional, or soon to be $1,000 if the fees increase as proposed. But if you've got 20 works at issue, that quickly adds up, and sometimes cases do involve a lot more than one work, so the $1,000 could become $20,000 or $30,000. some works could be registered in groups, but not all of them. Of course, it puts U.S. nationals at a disadvantage to non-U.S. nationals because non-U.S. nationals don't have to register before filing suit, which was something that I think it was Justice Sotomayor focused on a little bit today. And then we also think that it's possible that the number of actual registration applications could be lower as a result of this rule, because if some people in relatively low value copyright cases face this extra cost and burden, they may just decide, you know, this is not worth it. I'm not even going to bother to file the application, which doesn't help anyone because, as my friend said, we agree that the registration system is very valuable. The Copyright Office does very important work. And so we actually have a fear that you might get fewer registrations, not more registrations under the rule that office action is necessary. So those are all the reasons we thought the case was important and decided to file a brief.
So I will piggyback on this and say I'm also very glad I'm an English major. This was really an English major sort of Mexican standoff of statutory interpretation, and I was waiting for the punctuation parsing to start coming out. At the end of the day, I think this is a very valuable lesson in statutory construction and how statutory drafting can very quickly, without a whole lot of thought, go awry and only come to light however many years down the line when we get these kinds of 3-3 circuit splits. Just as some background, so Public Knowledge is a consumer advocacy group. We work on a broad array of technology and intellectual property policy issues, and copyright is one of them. I can confidently say that this is probably the single most in the weeds, wonkiest copyright issue we have ever worked on. So take that all in mind.
I have another one for you. Just filed a petition last Friday.
Oh, good God. I need a vacation. There's only 2 copyright people with us, and I'm half of it. So, you know, we kind of look at this because we focus a lot on policy. We came at this from the perspective of what are the rational incentives created by both potential structures and both interpretations of the rule. You know, starting from the premise that a complete registry is a more valuable registry, and since we have eliminated mandatory registration, then we need to go about other methods of incentivizing registration. Kind of 2 things to that point. One is that if you actually look at the congressional record, Congress was very, very aware that there was a standing problem with delayed, non-prompt registration of copyrighted works, even under the mandatory registration system. There were cases that said everything from 15 months to over a decade was still fine enough to be prompt. This made its way in the congressional record as a notable point of concern, and they looked at the new registration system where it was tied to certain benefits, such as statutory damages, as a way of actually incentivizing prompter registration, not more delayed. And so if you look at the 2 sort of universes presented by these 2 interpretations, a rational actor is going to behave in one of 2 ways. If you look at this as, if you take I don't remember what the exact terminology was because it has been a hot minute since we wrote the brief. If you look at the perspective that says no, an action must be taken by the Register of Copyrights, then the incentive for a rights holder is to register promptly upon creation. It is to get your work included, to do it as soon as possible after the creation, as a prophylactic measure against potential lawsuits down the line because there exists a risk of potentially throwing a monkey wrench in litigation. If you look at it, on the other hand, as, well, I've sent the paperwork in, that counts as registration, I've submitted the application fee and sort of done the necessary steps, that really sort of boils it down to a step 0 towards litigation, and there's very little to no incentive to register any work that you do not think at the moment of creation is going to be subject to potential future litigation. And so in that case, you end up with a registry that is not a registry of creative works. You end up with a registry that is a registry of works where people think they're probably going to have to sue someone over it. And those are 2 very different universes of works. So to the extent that we think the registry of copyright works is valuable and needs to be more complete rather than less complete, then rationally the system wherein you have to wait for a decision made by the Register of Copyrights is the more rational decision. I will also toss out there that I think everyone on this panel, and probably everyone who works in copyright policy on all sides, agrees that the Copyright Office really needs the tools to do its job. And I think we are all in favor of making sure that the Copyright Office gets the tools that it needs. I don't think anyone is rooting for long delays in registration or understaffing or technical difficulties or anything like that. I think we would all like to live in a world, I think, I don't have the exact statistics on this, but I had an exchange with someone right around the time the briefs were due, and I think the estimate was that registration time in 1988 was something on the lines of 6 to 7 week turnaround, as opposed to 6 to 7 months, which is what it is now, which can kind of cut both ways. You can say, well, then, rights wouldn't have been prejudiced so much if you allowed suit upon the moment of filing the application. But it could also say, well, Congress then would have completely thought that all of this time, you would have gotten an answer back in 6 to 7 weeks. So Congress absolutely would have assumed you would have an answer. So that would cut in congressional intent the other way. So the very short version of an extremely wonky problem is that there are arguments that it can that there are credible arguments that go both ways. And so we took a step back and said, well, like, from a law and economics perspective, what kind of universes are you setting up, and what are the incentives that you're setting up in these two possible situations for future actors to come along and operate in?
Can I?
Well, why don't I ask Rob to talk a bit, and then we'll come back and give everybody another round, okay? Rob, in light of what you've heard in terms of the stakes as articulated so well by the previous panelists, what do you want to add, and what information do you think that is important for us, and therefore, I guess by extension, we hope for the court in making its decision to have about how the registration process works?
Well, first of all, I want to say this is repeat what was said. This is a very important case. I need to thank Joel for filing this. I have been waiting for this case my whole life. So, that
Copyright law Christmas.
And I will regret it. That's the initial assessment, at least based on the commentary from the panel. But listen, it had to be decided either way.
Well, I'm glad that it's
You're
before
welcome.
the court. It's time for it to be decided, and so. I think, in terms of the issues that should be kept in mind, I guess one thing is that there are a lot of, I think, very good policy arguments why this perhaps should be different from the way the statute reads. But the problem is the statute doesn't read that way. If you read Section 411A, which is at issue in this case, I think you look at those first two sentences, and as Justice Kagan pointed out today, how do you read those two sentences in harmony and not come to the conclusion that they are equivalent, and that this, however, with respect to if the register refuses, is really also including in the first sentence that applications for registration, that registration having been made means the issuance of a certificate of registration by the Register of Copyrights. So I think, first off, that with the question for the court really is going to be, is what determination did Congress make on this issue? There are other sections of the Copyright Act that may cause some confusion about how that term was used in different contexts, but at least within the context of Section 411A, I think it is very clear. Some of the policy arguments about, the delay, I think it's probably fortunate in many ways that this case was brought now rather than a year from now or more, because I think in a year from now or before, we are going to be bringing those processing times down significantly, and in the past fiscal year have already made enormous progress in the amount of older claims that have been resolved, which is one of the reasons, if you look at the processing times that were posted on the Copyright Office's website, 6 months ago versus what's put on the website now, they actually got longer. And the reason for that is because we closed 70% of the oldest claims that were in the system in that last fiscal year. And we're committed to closing all of the claims that were prior to 2017 by the end of this fiscal year. And that's in my performance requirements. So I'm committed to that. We're going to get it done. And we're getting it done, too, with high quality. I think that's the other important aspect of what we have been working towards. We've completely overhauled the training that we do within the Copyright Office for existing veteran examiners, as well as the many, many new examiners we've hired in the last 4 years. So Congress making this decision about how the registration process should work and that the Copyright Office should be an intermediary and be of benefit not only to the courts, which I think it is in many cases a significant intermediary, but also to copyright owners themselves, because we do clarify and help a lot of copyright owners who, there are many copyright lawyers, some of them are members of the Copyright Society, which I will say, I'm in the Copyright Society band, so you can come to also to see that, but who may be members of the Copyright Society who still have their deficiencies in terms of filing a copyright registration application. We help them as well as the individual artist or author who does not want to learn copyright law, doesn't want to learn Copyright Office practices, but wants to get their certificate of registration. 30% of the 500,000 plus claims that we get every year result in correspondence from the Copyright Office. And in many cases, that is an effort by the Copyright Office that is not required by the statute to cure deficiencies in the application itself, perhaps in the deposit, or as in the case with Fourth Estate, the problem with a fee, which wasn't collected. And that's another issue that I think is missed in terms of the statutory interpretation, and that did not come up at all in the oral argument today, but even reading that first part of Section 411A, of registration having been made, how would a court ever know whether the Copyright Office received the application, the deposit, and the fee in proper form that met the legal and the legal requirements of formal and legal requirements of Title 17, unless the court asked the Copyright Office? The only alternative would be to rely on the word of the plaintiff that they had completed all of those. And, you know, there are many cases, and many that were cited, a few of them that were cited in the amicus briefs, where people said there was a very long delay on these particular claims. We looked into some of those claims, and at least in two of the three that were cited in one brief, they had, the deposit was sent a year after the application was submitted to the Copyright Office. And when we corresponded about that particular claim, we didn't get a response, and it was closed as a no reply, that we just closed that claim, and it was basically an abandoned claim. So it's an important issue that just in terms of meeting those legal and formal requirements, that the office be able to, you know, there are many times that we receive deposits that are deficient, that we cannot open, applications that have missing information or that are inconsistent with the deposit. And I think courts really do benefit from the assistance that the Copyright Office takes on its own. Again, this is not something that's required under Title 17. We have a binary function of either to register the claim or refuse it. But because we spend this time, and it is a lot of the time that examiners spend on these 30% of claims, we are able to benefit the entire copyright ecosystem. That includes copyright owners, it includes defendants, so that defendants have notice of what the claim involves, and I think it's a significant benefit to the court. I could go on for a couple days like this, but I also at least wanted to point to one point, because you know, there has been a lot of talk about statute of limitations and about injunctive relief and the problems of delay. And again, I think we're getting to a point where the amount of time it takes to examine a claim and render a decision is going to be significantly shorter than the times that we currently see. And that is already happening for claims that are coming in the door right now. But I think an important thing too that, is sort of dismissed is the office came up with the solution for special handling, for expedited service. And we receive about somewhere in the range of about 2,500 of those a year. And I'm setting a lower number, I don't have that in front of me, but about 2,500 special handling requests a year. As far as I know, we have never refused one of them. And the reason we would refuse it is that there are three bases that you have to, one of three bases you have to satisfy to obtain special handling in addition to the fee. You either have to be in pending or prospective litigation, you have to have a customs reason for filing the claim, or a contractual reason. And in the electronic application, we have checkboxes that you would choose which one of those bases is the reason that you're requesting special handling. And we take the applicant's claim at face value. We don't look behind it and search whether there actually is a contract reason. But in any case, I think that we have approved 100% or close to it of the special handling claims. And yes, it is $800, but it does get reviewed within 5 business days in almost all cases. Mistakes happen everywhere, so I won't say it's in 100% of the cases, but I will say in the vast majority, they're reviewed within 5 business days. And the cost is high, but the AIPLA's recent report, well, I think at least one that I saw cited recently from 2015, the median cost of a copyright infringement case of less than $1 million is $250,000. So when you think about the cost that is going to be involved in infringement action anyway, $800 is not that much money in comparison to what the attorneys are going to be making in that case. So I think I'll leave it for there for now.
So let's go, as I promised, and hear any second round of comments on the question of what's at stake, starting with Joel.
I think there's a couple of comments. As much as I was a fan in law school of the whole law and economics theory, and antitrust was my favorite class, in the last 28 years, I've moved over completely to the behavioral economics theories, which have nothing to do with the idea of rational actors as they're understood in economics. I represent artists, illustrators, photographers, not too many actors, but they're certainly not rational actors who I represent. I mean, if you're interested, Google sprinkle poo copyright infringement. I filed that case on behalf of an illustrator who is probably the least, she's certainly the least rational actor I have ever come across. People who rely on the copyright system, for the most part, haven't read the Copyright Act, don't understand the process of registration, can't be bothered with it. They're creative people. They are much more interested in moving on to the next creative endeavor, far more interested than they really should be. And they should be educating themselves, and they should understand what is required. But they generally don't, And that's when they come to see me. And they have a problem, which is that the valuable thing that they created, whether it was yesterday or years ago, is being ripped off, and it's being ripped off in a way that would never in a million years justify anyone spending the $250,000 in legal fees that the AIPLA thinks is, the average amount of legal fees that are spent on a case in this country for under $1 million. I am only one of the many respondents to the AIPLA surveys, and so I cannot skew the results. I certainly agree that there are lots and lots of cases that are worth less than $1 million that are worth spending $250,000 in attorney's fees on, but that's not happening at my law firm because I'm representing creators who don't have that money and who are victims of infringement and who are losing money day in and day out and who have no other recourse other than to obtain an injunction, to obtain damages, who in most cases can't justify spending $800 or what will soon be $1,000 to pay for special handling because they may not even have statutory damages claims. To get in the courthouse door, should we lose, which is a good chance, the cost will be special handling if it goes up to $1,000 plus $400 to file the case plus another $100 for process server, and now we're already at $1,500, which is double the minimum statutory damages, but if we can't even recover statutory damages, then what are our actual damages? And while I applaud proposals like the copyright small claims court, it can only be a voluntary system unless Congress comes up with another way to do it, which of course they won't. I want the Copyright Office to continue to do all the good work that it's doing, and I want them to absolutely be rolling in money, especially money to upgrade the computer systems and to increase the processing times. I really do want that. But the reality is that my clients, Liza Phoenix, creator of Sprinkle Poo, and many others, this is not a system that in today's world is working for them. I'm gonna shut up now.
Others, Elizabeth.
So I think it's a great question. I feel that in any given case, there could certainly be ramifications that seem unfair to a given individual with a claim. But I feel that Congress here, with the rule that we believe they chose, and to be clear again, we represent the respondents, so I represent the side whose view is that when 411A said registration had to be made or refused, that the Copyright Register had to act and either grant registration or refuse it, not that a mere application is enough. Now, why would someone want to have enacted that rule? We believe that Congress had good reasons. One was to, as the public knowledge amicus brief pointed out, encourage people to register their work and provide a copy to the Library of Congress promptly, regardless of whether they thought that someone was infringing it. That's useful for the public at large, and let me give you one example of how that might be so. I think Joel mentioned earlier in this panel that a lot of people out there believe that things on the internet might be free to use, publicly available, just because they're available online. That's obviously not true. Public service announcement, you need to either verify that something's in the public domain, or you must get permission before you use it, or you'll need to come to an attorney for help, and you definitely don't want to be in that position. Well, if people register promptly and the works are in a publicly available database, it's a lot easier to get to figure out who to ask to get permission. So the idea of developing a robust system where people are incentivized to register is one motivation that we believe Congress had in keeping this requirement. And we call it a formality, but in some sense, it has substantive effects for the system that are far from formal. The second thing that this rule does is it serves as a speed bump that deters or at least helps rationalize spurious or exploitative litigation. Frequently, a copyright claim frequently when this point is made, people envision baseless claims and malicious plaintiffs. I don't know that you even need to have that scenario in mind if you're Congress deciding which rule to pick. But if you file your registration early enough that you qualify for statutory damages and attorney's fees, that's kind of a big hammer. Getting to file a federal lawsuit if you're a litigant is a big hammer against the defendant because now they're going to have to hire a law firm, pay money to prepare an answer. That's expensive. When you're presented with a claim and the lawsuit isn't filed yet, frequently defendants work that out, in my experience anyway. And there is holdup value, we would submit, from the ability to rush into federal court. Congress may have wished to deter that or at least at a minimum slow it down. Now, the flip side of that is, will the statute of limitations run and really hurt a copyright claimant? And in my view, that concern is overblown. All of the parties in the amici in this case could come up with only one case from many, many years ago where it was submitted that the statute of limitations had actually run. And in that case, the court said that the plaintiff had been dilatory. And so I think because the statute of limitations is typically rolling, it goes 3 years back from when you file suit, and the delay we're talking about right now is only really usually a matter of 7 months or less. It's very unlikely that you'll have a litigant whose rights will be eliminated. And Congress could have made a rational choice, and we believe did make a rational choice, to adopt a regime that would at least slow things down and require the administrative process to play out. And finally, and maybe the biggest point, is the point that there is value to the interaction with the Copyright Office. You may try to register a claim and the Copyright Office may say, wait a minute, this isn't right, you have to adjust it. You're claiming a compilation, but your compilation isn't original, or changes are made in that process. Not insignificant amount of the time. And both the changes themselves that result in the grant of a valid copyright, and also the back and forth between the Copyright Office and those parties that's then available on the public record for other people to learn from when the claim registers, that's valuable, that's important. The people I think who care about this decision are people with systemic interests, either on the plaintiff's side or on the side of wanting the system to be robust, and those are valid. And I think that's why sometimes from the perspective of any given litigant, the situation will look different. When you look at it with a systemic view, then I submit you will care, or at least I care very deeply.
So I will piggyback on that and say, this is my usual soapbox spiel. Copyright is an ecosystem. Everyone is impacted by copyright. It is not and has never been exclusively about the rights of artists, though it is in large part geared towards protecting the rights of artists. It is also, there are baked in safety valves for everything from end users to libraries to preservationists to historians to archives and all the way down. I do a lot of work with the game archivists, people who work on preserving video games, and specifically preserving video games that are either made for systems that have long since disappeared or were small independent releases where there are no known rights holders currently living, or there may be one copy that someone lifted from the offsite storage when they got fired in a fit of pique, but otherwise the game has been destroyed, those sorts of situations. And I will say that especially in this particular avenue, one of the things that comes up overwhelming frequency is the problem of orphan works. And orphan works is what happens when you have an incomplete registry of copyrighted works. And so this goes back to kind of what I was talking about earlier in having the value of a more complete rather than less complete registry of works. You have parts of the history, and I pick on video games for a handful of reasons, one of which is that they have only sort of comparatively recently gotten the cultural cachet to be considered worthy of archiving, other than to a sort of dedicated nerd few like myself. And so there is a history of small studios that started up in someone's garage. They maybe didn't have contracts with each other, and then they got into a fight, and the game disappeared. Someone walked off with the only floppy disk. And now we don't know who actually owns the rights to it. They don't know who owns the rights to it. And so you're prevented from actually doing anything with it because you don't know who to contact in order to make a use of this work. And that's doubly compounded when these things are not in any centralized registry. They're not easily obtainable. Sometimes, in many cases, the studios have gone through a chain of ownership. I mean, this happens in music all the time, especially with older works. There's just, purchase upon purchase of studios, and a lot of things get lost in the shuffle. And so all of this is a very long way of saying the importance of having a registry that is comprehensive and timely is not just a concern to sort of wonks like me who just happen to think that the concept is very valuable, but it's a very real necessity for anyone engaging in any kind of historical archiving or preservation work. And frankly, even a lot of small end users. So another community I work with some frequency are video game streamers, people who operate on Twitch, who have channels that they. So there's a gentleman called the 8-Bit Drummer, I recommend you look him up. He's got a really cool channel. He's just a drummer, and he sits there and he takes requests, and he will, if he has the rights to a song or he's gotten permission from someone, he will play. You can send any request his way and try to challenge him, and he will sit there and attempt to noodle it out on a live stream. It is exceptionally difficult to figure out who they need to be talking to for a lot of these works, especially when you get, again, older works, or works that maybe are subject of a video that went viral on YouTube, and there's there isn't a traditional sort of industry apparatus behind the creation and marketing of a song. And these folks very much want to be able to contact the people they need to contact because they realize that they are opening themselves up legally to a lot of liability. That information is not there for them. It is not there easily accessible even to the lawyers that many of them hire, because once you get big enough, you do expose yourself. And the absence of having a sort of a large comprehensive registry of copyrighted works exacerbates these kinds of new creativity, which are getting bigger and bigger. If you haven't been on Twitch, you probably have a niece or a nephew or a child who has. Don't worry, I don't really understand it either. But this is the kind of creativity that is taking place in the margins and is becoming larger and larger, and really does depend on having that kind of information accessible and ready and out there.
But the information's so limited. I mean, I hear the idea of the registry. I think it's wonderful, and it's been argued extensively in this case, and it's great. But what is it that we're talking about when we're talking about a registry? Because you go to search the Copyright Office's records online, and you have a title, author, dates. It's very limited. I had a call, a woman called me on the phone and claimed that Selena Gomez or someone had copied her song because even though the lyrics were different and the music was different, the title was the same, and there were some hooks in it. She knows that once you register it, it's on the internet for anybody to go and listen to and see and all the rest of it, which is completely untrue, and she didn't believe me. It's like, so, I mean, great, but does anyone know if I were to say, Magritte's painting of the man in the bowler hat with the green apple in his mouth? I mean, you visualize that, you know what that painting looks like, it's so famous. Well, it's not called Man in the Bowler Hat. It's called Son of Man, right? If you didn't know who the name of the artist, Magritte, and there were no keywords associated with it, you can't go to the Copyright Office and look at the image. It's not in the registry.
Well, we should, you still have a week. We have a notice of inquiry out right now. That the deadline for comments is January 15th, but it's with respect to modernization of the registration system. And we have about 35 questions in there, and invite any other comments that people have. But a lot of it gets to your point and some of the points that were being made about, it's not just what is now, and so we have what is for, that's posted for processing times right now on the copyright site. We have the system we have right now that we've had for the last decade. But we have gotten support from Congress over the last 4 budget cycles. We have a budget this year, and we hope to have it next. But I think that we're on track now in terms of the number of examiners with FY19 and the number of additional new examiners that we'll be hiring, which will be bringing the level up to almost 140 examiners, which is double the number of examiners that we had when I came into the registration program in 2013. That we have enough to be able to handle this, and we are spending, really the focus of what we're doing now is committed to building this, in addition to keeping the examination process functioning very efficiently, better than I think it has in a long time, with quality and speed, that we are committed to dealing with that situation that you mentioned, where many people don't know copyright law, and they don't want to know copyright law. I mean, we've found that in the office for a long time. We correspond to people who do not want to be taught copyright law in these letters. What they want to do is they want to know how to fill out a certificate of, how to fill out their application for registration in order to receive a certificate of registration. And the approach that we're taking would be working with a lot of these different issues that have been mentioned, where we would have a conversational tone for novice users that they wouldn't have to understand. It would be kind of like the TurboTax version of a copyright application process. We'd have a formed view for experienced users. Plus, I think what gets to your issue, I don't know if we're ever going to have the resources to have a state-of-the-art registry or registration system that is going to accommodate the enormous array of copyrightable authorship that we do examine. I mean, it's an enormous spectrum of copyrightable works, and each of the categories of authorship in Section 102 have a large number of different industries within each one of those categories. But what we want to do with the new registration system is something that we've heard for a long time, is that if we can't do it all, we want to open our system up and our registry up through APIs and other vehicles so that third parties can build on top of what we have. So we can have, for those visual artists, that they can have a third-party registry that they are willing to put their works into, so that thumbnails or something else, so they can be identified other than by a title. So I think now is not the time to sort of restrict and to eliminate the benefits of registration, which I think in many ways this wouldn't stop us in the direction that we're going. We're going to continue going here no matter which way this decision turns out. But I think the view of Congress was, and the support that we have been getting from Congress over the past years shows that dedication to wanting to get it to a place where it will be able to accomplish these many tasks better than it ever has before.
Yeah, if I could just respond to some of what's been said.
Yes, I would want, please, Matt.
Sure.
I want to go in a slightly different direction in a moment.
Sure. There's been a lot covered, so I'm not going to try to respond to everything, but there were a few things that I wanted to talk some about. Rob was talking about the expedited special handling, and it is a much more expensive approach. Justice Roberts today referred to it as the first class option, and I just don't believe when it comes to getting into the courthouse, there should be a first class and a second class section of the plane. Smaller artists should be able to get to court without having to pay the first-class ticket price. The other thing is, I guess I'm a little more optimistic than my friend about today's arguments. There was some reason to think that a number of the justices initially, at least during the argument, read the statute the way the respondent would prefer. But I think the petitioner's attorney, Mr. Panner, did a good job of explaining why that's at least not the only way to read the statute, and is likely not the better way to read it. And as a result, you started getting more questions from the justices about the policy issues in the case, about congressional intent. And so I do think that there's a possibility that they were convinced that even if the statute isn't 100% clearly in favor of the petitioner's position, that there's some ambiguity and they're going to have to figure out the best way to resolve the case. And so that does get us into the policy arguments I was talking about earlier. In terms of the incentives to register, this is not the only one, of course. You can't get attorney's fees or statutory damages unless you've got your registration in a timely way before the infringement, or with published works at least within 3 months of publication. For a lot of people, that's a much greater incentive than just getting into the courthouse, and that's still going to exist. You have to file timely to get prima facie evidence in court from the facts stated in the certificate. That would still be there. And so if this is read to allow for the application rule, those incentives don't go away, and the values of the registration system will continue. The value that was discussed of copyright owners interacting with the office will continue. The application will still have to be on file, and they'll still have to interact with the office if questions arise. And if they decide based on those interactions that, hey, my case isn't as legit as I thought, then maybe they'll walk away from the case. The other thing is, nothing about the application rule prevents the Copyright Office from offering its opinions to a court, or prevents the court from asking the Copyright Office for its opinions. The Copyright Office very, very rarely gets involved in litigation, though, and so I do think to some degree that's not a practical problem in most cases, but it is an important instance when the office decides to get involved. But nothing about this case will stop them from getting involved at all. Ultimately, even if the Copyright Office has rendered a decision, the judge has the final say on copyrightability, on whether the registration should have been issued, the certificate been issued, and that will continue regardless of the outcome of this case, either way. With respect to the registration files being comprehensive, that's just never going to happen. Every copyrightable work is copyrighted from the time it's created, and there's no way that every single one of them is going to be registered under the current system. As Peter said, some folks would like to go back to a more formal system, and that can be debated, but under the current system, that's not going to happen. It's not going to be comprehensive. There are other issues there as well. Even if a registration certificate's been issued, if the copyrighted work is sold, there's no guarantee that the new owner is going to get a new certificate. And then so you're getting into issues of recordation and things of that instead of registration, which are separate and apart from 411A. And then the last thing, just quickly, is Meredith touched on the orphan works problem. There's been legislative proposals for quite some time to try to solve that issue. Many of the original proponents of those legislative proposals backed away from them and no longer support them. So I think that's a different policy issue. If that issue needs to get addressed, it should be through orphan works legislation of some kind, not through trying to read Section 411A in a way that I don't believe it was intended to be read.
There's a question it's a great interest to me, and it's been touched on in a number of different ways by many or most of you, and that is, why do we collectively, practicing lawyers, copyright office, educators, why do we do such a bad job, or have we done such a bad job, or why have we failed so comprehensively in making it clear to working creators that there are enormous benefits and relatively low costs associated with registering something when you make it, if you think it might be of future value. I used to, as some of you remember, I used to tell my students that not counseling a creative client about the advantages of early registration is tantamount to malpractice, it has seemed to me. Now, obviously, Joel, some of the folks who were contacting with you weren't your clients at the time when they faced the register, no register decision. So I'm not faulting you or anyone. I'm just wondering if you all have any views of how, given the situation and given, as I think has been acknowledged, the fact that missing out on statutory damages and attorney's fees may be an even greater cost to creative people than missing out on the possibility of a TRO. Where have we failed?
I don't think we failed. I think, from my point of view, I answer the phone when the person calls and says, you know, my photograph, my illustration has been infringed. I say, is it registered? They say, but I don't have to register it to own a copyright. The Berne Convention for the rest of the world did away with that formality, and it is the thinking of most people I encounter that I didn't know I had to do anything else in order to own a copyright. Of course, they didn't have to do anything else in order to own a copyright, but they did have to do something else if they wanted to sue. And it is only the repeat clients, right, it is only the repeat clients, once they've experienced the power that their registration provides them, then you have, I mean, then the next thing you know, you have case after case after case of registrations, and they have gotten the religion.
So I'm not suggesting that your office has failed. I'm suggesting that collectively all of us have failed somehow to get the word, which, as you point out, people learn very quickly from their first experience how in advance.
Yeah, I mean, every decent copyright lawyer blog post that I've written, that I've read by other lawyers, I mean, we constantly are reminding people that this is a very important thing that they need to do if they want to enforce their rights in the United States. Why they're not getting the message, I don't know.
I think one thing that Copyright Alliance was created to try to do is help with education of the individual creators. And I think they've made good strides in that, but there's still a long way to go. I think there's been a lot of good work on other issues, such as the fair use best practices that you've worked on, such as legal clinics devoted to trying to help artists understand both sides of things, when they can engage in fair use, but also when they need to register. And so there's a lot of efforts, but it's a big, big world, the world of the creative artist. And I think the public knowledge brief rightly referred to the industries driven by copyright as quite dynamic. Those kinds of people aren't naturally inclined to do a lot of paperwork. And so it's a struggle, but I do think good efforts are being made, and progress is being made on these fronts.
I will say, I think I think what we see in copyright is systemic, or is a symptom of a larger just trend. And I say certainly in American society, I can't speak to much others, but no one wants to be the person who tells someone going into business, you need to have a lawyer. I think that lawyers, and this is a problem more sort of with the legal profession, lawyers are viewed as someone you only go to on your worst day. They are very rarely, I think, unless you are a particularly unique individual, seen as something essential to your business model from day zero. And so I think part of it is that most people don't want to engage a lawyer until they already know that they have a problem. And if they already know that they have a problem and they are engaging a copyright lawyer for the first time, they probably do have this intuitive sort of belief that I don't need to register. I have a copyright, so I should be able to do everything that I believe that I can do to execute that right. But unfortunately, that in copyright's case happens to run up against a particularly, frankly, Byzantine system of rights and limitations and actions required on the part of creators and users alike. And so when you have that natural impulse, I think that, like, I don't need a lawyer. Why would I need a lawyer? I'm just like doing painting commissions for a living. Like, why would I need to get a lawyer involved in that? And that suddenly runs up against things like attorney's fees and statutory damages and, you know, ability to bring lawsuit to federal court, which is not the first thing anyone is thinking about. I think that the two of them together naturally create this sort of perfect storm where popular conception runs up against the actual law.
Although, of course, one doesn't need a lawyer to initiate a registration. Rob, what do you think about this issue of, for lack of a better word or better words, public information around these issues?
I think there's a number of different issues. One is that I don't think that we have done a very good job of explaining to different kinds of creators what the benefits of registration are. We have these sort of statutory benefits, prima facie evidentiary presumption, and the ability to initiate a lawsuit, statutory damages, attorney's fees. That I don't think rings as being something that is very important to most creators. And when you put that together with the fact that when you do look online, there is a lot of misinformation out there. And even if you get accurate information, it may not give you the full story, like the fact that copyright subsists when you fix in a tangible medium of expression. Well, an original work of authorship in a tangible medium. That's true, but you know, there's more to the story. So I think two things that I think would be helpful, and I think we've worked closely. I personally have worked with Copyright Alliance to provide answers to countless registration-related questions that have been posted on Copyright Alliance's website. The Copyright Office also, now that we have hired what I think is a sufficient number of examiners to get us where we need to be when they're fully trained, that we are beginning to put our resources in our Office of Public Information and Education and have plans for videos and a host of other different initiatives to be able to explain these benefits and others about the copyright ecosystem to more people. And lastly, I think that this is not typically the kind of information that art schools really deal with. Writers or whatever, photographers aren't necessarily, that there are exceptions to that, and I've worked with some individual photographers and organizations that do a lot of copyright education, some which actually require their photography class members to all file a registration, an application for registration as part of the course. And I think if we could see that happening more through more creative industries and sort of creative educational institutions as being part of that understanding that copyright registration is really, you need to think of it just like you think of, in addition to the registry aspects of that and the ability to be recognized as the author, to be able to be found, I think in addition to that insurance policy in case you are infringed and you do get those statutory benefits. And if we can do a better job of both with the Copyright Office and other organizations as well as different creative institutions, I think that we would do a great service. Whether that could fully displace the misinformation that you can often find online, I don't know, but we can do what we can.
Can I say that the recognition point is the most key in my experience? What does every author, I use the word author as the Copyright Act uses it, right? Which is to cover any creative creator. What do they want? They want recognition. I think that if the registration system could provide that recognition, then you would get a much more educated participant group, because that's another way that they can be recognized. And, I mean, it pays so little to be creative anyway. I mean, you might as well get some recognition for it. So that would be wonderful.
Before I want to make sure that we have time to do questions and answers, but Elizabeth, do you have a take on this, on my question about where we've all gone wrong?
Well, the only take I'll give is that you may have a little bit of selection bias because the cases that probably come to you are the sad stories, but I do think there are a lot of successes out there, including creators who know that they can register without lawyers, and I think there are even a bunch of disputes that do manage to resolve without a lawyer, and that's a good dispute.
So, I have many more questions, but I don't want to harm the attention of our wonderful panel. So, Jonathan, now there's a mic. I think it's on. I'd ask you, for the benefit of the record, to, I guess, identify yourself and ask the question.
I'm Jonathan Band, and I'm just curious, what happened at the oral argument?
It was good. For both sides.
It was hard to read Justice Ginsburg's body language because she wasn't there, which was sad.
But Chief Justice Roberts did say she is taking part in the decision. She will be reviewing the transcript and all of the briefs.
She's on our side anyway.
I guess I spoke a little bit to this already, but I do think that early in the arguments, there was some indication that I think probably Roberts, Breyer, Kagan, and Kavanaugh all saw the statute to favor the respondent's position. Over time, though, I saw some cracks in that, and I think that the only one who maybe I didn't have a sense was considering whether to change her mind was Justice Kagan. And Kavanaugh twice asked the petitioner's lawyer to start speaking more to the policy arguments and said, I think your position is essentially that we're going to have to get beyond just this language, and so tell me more about these harms that you're talking about. He never got around to listing all of the ones that I listed today, but he did reference that they're in the briefs. And so I wouldn't predict one way or the other how it's going to come out, just because of the kind of progress in the thinking that I think I saw of the justices today.
I will caveat this by saying, as someone who's not a member of the Supreme Court bar, I got to stand outside for 3 hours. It was very cold. I had 3-inch heels on. Yeah, I'm still recovering. But I did catch the second, so I managed to get a seat for the respondent's argument and then the respondent and government's argument, and read the transcript subsequent. I will say that generally Roberts is very engaged. He was asking good amount of questions, tossing them both sides. Thomas was present. Alito was similarly present. Kavanaugh was also pretty engaged. I will say that in terms of just, there was not the kind of lengthy back and forth. I think there wasn't really as much of a drill down as I have seen in some other cases. So I'd harken back to Star Athletica, Varsity Brands, where there was really, you would get, a couple of justices would really latch on and kind of dig down one thread of argument for a long period of time. There really wasn't that. There was a lot less questioning, in my understanding, on the respondent's side and the government side. There was more active questioning on petitioners. I can't read Gorsuch. I don't think I'm particularly alone in that. But yeah, it was definitely, folks were engaged, but I think it was a much more subdued oral argument than many other, even copyright cases that have come up there.
Well, I want, in a moment, of course, I wanted to check whether there were any other responses on the panel to Jonathan's argument. And then also to ask whether there was anyone in the audience who was at the argument who might have their own take or commentary on what went down. And the floor is yours.
Oh, you want to?
I'll say it after.
So I was there at 6 o'clock in the morning, got the 45th seat. So I was actually surprised how packed it was. But to your point, Matthew, when Justice Kavanaugh kept wanting to get the petitioner's counsel to answer what the problem for a copyright holder to wait is, and I held back, but I wanted to yell money because I just feel like at the end of the day, for the copyright holder, that's what they're losing on is money, whether it's the damages or just the filing or having to expedite or whatever. So Professor Kazanek, since you always push back in class, I'd like to ask you what you think, the copyright holder is losing money. What do you think the Copyright Office is losing out on in allowing the holder to just initiate litigation without the certificate of registration?
Well, I think the benefit of seeing exactly, what the claim is. So one thing that I think that the problem with the application rule is that it can cause mischievousness in litigation where we have people specifically wanting to sue under the application rules so that the judge will not receive the benefit of the Copyright Office's views. So, any kind of litigation involves, in the harm of the damages to a copyright owner can be significant. And we do have, I think there was concern about in the digital environment how that can happen very quickly. Congress did address that in the Digital Millennium Copyright Act with notice and takedown, and that is something that can at least ameliorate those damages. It may not be the same as an injunction, but then when you put that together with the $800 versus weighing that with the balance of what kind of financial harm and damage is occurring, I think that's a judgment call that has to be made. But it is a balance, and I think losing out on the benefit, there is the other side of the coin where this is having that Copyright Office sort of filtering of claims and ensuring that the legal and formal requirements have been met, that we actually did receive a deposit, and the deposit has some semblance to what the application title said it was. There's value in that, particularly if this is going to lead, even if this leads to cease and desist letters where you're pointing to a certificate of registration. That involves money for defendants and costs there. So I think in balance to the copyright ecosystem that it really is important. And I would hope that in the future, as we can create a more efficient system, we're working very hard now to figure out ways with a new system, but even with the system we have, of reducing some of our costs in the amount of time and money that we spend as the Copyright Office trying to help applicants through correspondence. If we can do that through the copyright application itself in a new re-envisioned form, I think ultimately what we'd like to see is being able to lower the costs of registration and a lot of different services that we have, allowing other entities like through APIs to offer additional or ancillary services to that. So, it's easy to point to one particular situation, one perspective, and see they're being harmed, but I think the reason that I've liked being in the Copyright Office is trying to look at every issue from all sides and trying to find and I think that that's what Congress did in the statute and subsequent amendments to the statute as well.
So if it's all right, I'd like to piggyback on that. You have to take this sort of in conjunction with the proliferation of the internet. I mean, that's always going to be the 800-pound gorilla in the room when you're discussing copyright. Culturally, as we've sort of discussed already on this panel, there is a limited / divergent sort of view of what copyright is between copyright lawyers and the general public, as evidenced by you have everything from it's on the internet, it's free, I can do whatever I want with it, to very rarely will I defend Taylor Swift in a copyright context, but she has gotten slapped with some pretty ridiculous lawsuits accused of having knocked off other people's work. I think it was, so Sarah Jong, the former tech reporter, had a great line where she said, we've sort of been conditioned to view copyright as the way that you get things off the internet. It's an incredibly powerful tool when exercised. $150,000 per infringement statutory damages. That's an immense amount, even to claim in a cease and desist letter. So if you do have a situation where submitting paperwork to the Copyright Office and the filing fee, which is not trivial, and I will assess that, it's, someone has to pretty much have a vested stake to put down that kind of money. But that pales in comparison to being able to potentially reap $150,000 from an under-resourced defendant. And a lot of times when all you really want is just to see them stop doing whatever it is that you want them to stop doing, even if it's not actually a copyright infringement claim. We've seen copyright brought to bear in all kinds of cases. I mean, I think about Google v. Garcia, which is about, was a case involving a woman who was victimized. She responded to an ad to show up as an extra in a sort of an amateur production movie that was billed as being an homage to the life of the Prophet Muhammad, which should have been a big red flag. She showed up, she spoke a couple of lines, totally innocuous, got her $50 or $100 and went home. Turns out the guy who was actually making the movie wasn't making a biopic about the Prophet Muhammad in the way that she thought, and he overdubbed her voice and made her appear to say all these incredibly inflammatory things. It went up on YouTube. She was inundated with death threats because people thought she was actually saying these things. And in her quest to take it down, one of the things that she claimed was, I have a copyright in my particular, 2-line appearance in this movie. So she ultimately didn't succeed. It was an incredibly sympathetic situation. But at the end of the day, there wasn't actually a colorable copyright claim in her performance. But we see people use copyright in all these ways for which it is not designed to be used, primarily to curtail some kind of speech, whether we agree with that or not. Again, on the other end of the spectrum, people have used copyright to address the lack of revenge porn laws. People say like, oh, well, it's a selfie, so it's a copyright, so I take it down, but can you use it if it's someone else's photo of you? And it ends up becoming a tool for a lot of things for which it was not intended. Some of those can be spurious. Some of those we don't think are particularly socially valuable. But at the end of the day, it is a very, very powerful tool. And I think there's a substantial interest both for the public, for the consumer public, for the user public, for the government, and for creators who often rely on things that incorporate elements of previous works to make sure that it's not abused. Because it is such an incredibly powerful tool. And so to prevent that, what you don't want to do is have a situation where all it takes is filing, again, an admittedly not insubstantial amount of money, to be able to, here's my $200 and now I can stop that guy from saying things about me on the internet. And you do have those kinds of risks.
Oh, before the next question is asked, may I just I'll briefly give a little bit of an actual answer to the original question. I think today's argument reflected a court that is typically very textualist and two very skilled advocates who understand that. And so we didn't hear a discussion at oral argument that was focused on the policy issues because this court believes that those arguments are to be presented to Congress. So I think we heard an argument where the justices understood the issues and were pressing both sides on why their interpretation of the text was superior. That doesn't mean the court will ignore completely the legislative history or the policy, but certainly if you listen to the transcript or read the transcript, it'll be focused on what did Congress mean here, not what do we wish Congress meant or what rule should Congress have adopted. And so for the law students, I think it would be a good exercise in the need to understand your audience. And sometimes even the most gifted lawyer can't, you get what you get. So I think it'll be very interesting to see how it turns out and probably not really driven by any of the policy arguments that we care so much about.
I can see almost no benefit to registration when it comes to litigation. I'm not talking about the repository of cultural property in the Copyright Office, Library of Congress. And the court may decide, based on the language and everything, that a registration is valid. But since we've gone off on a policy thing, requiring a registration harms creators and helps infringers, and that's all it does. We don't have an online database yet where we can see deposit material, so it doesn't help us identify what the materials are. The only reason anybody files registration today is for litigation purposes. After you've been burned once, you file early, so you know you get your statutory damages and attorney's fees. You file to get into court. Creators do not file for any altruistic reasons that they want to enhance the Copyright Library of Congress database. For all the reasons that Joel and Matt said, there are a lot of downsides. There's absolutely no upside. The Copyright Office will review the things, but if you ever actually practice copyright law in court, you know that the presumption of originality or ownership that comes with if you file within the 5 years, you argue it anyway before the judge. If there's really a question of originality or ownership, you have a rebuttable presumption from the Copyright Office. Judges make their own decisions. You know, they can, okay, there's a burden. But again, if you've ever actually litigated cases, you know, the burden doesn't really matter that much. It may end up in the opinion, but when you're actually standing there arguing the case and trying to convince the judge or the jury, it's usually the judge because of the jury instructions, basically, the presumptions don't matter. You're going to convince the judge that it's an original work. You can convince the judge because it's ownership, and that's all it is. We have Rule 11. You're talking about frivolous cases. If you need to plead that I filed the application, I filed the deposit material, I filed the money, you put that in your pleadings. Under Rule 8, you have to do that. You don't lie. You have Rule 11. So you're not going to have abuses there. You're not going to have frivolous cases being done. You know, you have Rule 11, you have Rule 8, you're going to have pleadings, you're going to do it. The only thing this does, and I can't tell you how many times we can't get into court in a timely manner, and Rob, God bless if you can get it down to 6 weeks or 6 months, that would be great. But when you're negotiating in an infringement case, and I do about 80% plaintiff, 20% defendant work, the leverage that an infringer has when you don't have a registration, you can't go into court, say, okay, I'm going to come back in 6 or 8 months and file suit. You have no negotiating leverage in real life. They say, fine, come back in 8 months. It's just, there's no upside in the litigation point of view for anybody except an infringer to have a requirement for registration. Not saying that's not what the statute says. I think Justice Ginsburg already ruled on that, previously in her dicta. So I have a feeling that that's the way it's going to come out. I just think since we all went off on a policy thing, I just think it's a terrible policy from one who's been doing this for more years than I'm going to admit.
Well, I don't know where to start in how many ways you're wrong, but
It wouldn't be for 20 years.
I know
relationship
that you
agreed.
try to file a lot of applications. Well, I'll leave it at that. But that I don't, and maybe your clients do not care about the other parts of it. But out of the 500,000+ applications that we see every year, there are many, many applicants who. It's not for litigation purposes that they file these claims. We see across the full spectrum of authorship, individual authors who just, it's really, recognition of this is mine, I want that claim in this public registry of it for, their view of the value of their work. And we don't pass judgment on the value, we pass judgment on sufficient creativity. The vast majority, 97% probably of those claims make the grade. Although I will say that number is deceptive too, because we refuse less than 3% of the claims. But one thing that didn't come out as clearly today, although it was in the briefs, was that there are about, with that 30% of correspondence that we have for claims, that there are about 30% of that 30%, or about 9% of the 150,000, which is not of the 500,000, excuse me, which is a significant number that just basically get abandoned because they do not return correspondence to the Copyright Office. So, and saying that it doesn't matter in any cases, yes, Congress chose, unlike the 1909 Act, in the 1976 Act, not to make a certificate of registration the only key to the courthouse. They liberalized the Copyright Act and allowed, specifically to allow under Section 411A for to be a requirement to receive a certificate of registration or a refusal of registration, if there was notice served on the Register of Copyrights, and the Register had that absolute right to intervene in that case. And I've been involved in at least one intervention in my time in the Copyright Office. Yes, we do it rarely, but in most of these copyright infringement cases, the attorneys on both sides, it's not something that we need to get involved in. We feel confident that the attorneys on both sides of the issue can present the information to a court and resolve the issue correctly. In certain cases, we may choose either through direct intervention into the case, or through some other mechanism like a statement of interest in certain cases to get involved. But I think I've been teaching for over 20 years now, and I think in reviewing the case law, and you see that courts really do, it's not just the presumption of validity in the statute, but I think courts really do look to the expertise of the Copyright Office. And we see more claims every day in the Copyright Office than the federal courts see in a year of litigation. And we see it across the full spectrum, often decades before those issues ever hit the courts. So we're looking at, there are issues coming up now with choreography litigation that we dealt with and we wrote decisions about a decade ago, which would welcome input from the courts, but courts in many cases on many different difficult copyright issues really don't want to be the first ones to address that issue, and they look to at least starting the discussion. They don't have to follow us. We get Skidmore deference to the extent that we can persuade and show our work. And that's something that we're doing also, I think, much more in the applications or the certificates of registration, is we're not just issuing the certificate without any comment. In many cases, we're annotating those certificates to specify what the basis that we made that decision on, what regulatory basis, for instance. And that's one thing that I think really cuts against what you said, where it doesn't matter. Yeah, judges can disagree with the office on originality or copyrightability. They can agree on other issues. There's some things that they can't disagree with the office on. They can't disagree with us that we did get the deposit when we never did, right? That's a fact issue, but they're not going to know unless they have our opinion on it. In addition to that, I think with group registration options, which are authorized by Section 408C in the statute, the 1976 Act gave the Register of Copyrights the authority to create multiple work registration options for the first time in the 1976 Act. Those have very specific eligibility requirements, which you know all too well, Josh. And in many cases, those are going to be a bar to multiple works. It was the very issue in Fourth Estate for why we refused it. We said this was not a group database option, but this was a chronological listing of news articles, which does not have the requisite amount of creativity for a compilation, which is required in a database, under the Supreme Court case in Feist. So I think that those are issues which at least help inform the litigation and are really very important. And the same thing with refusals. When we do refuse a case, courts have the ability to look at, to disagree with us. That's built in, and that's the reason in section 410D, why it even lists a court of competent jurisdiction in that phrase about the effective date of registration, because if you look at the legislative history, it's very clear that they intended the court of competent jurisdiction to be able to assess that effective date if they disagree with the Copyright Office's decision. That's the only way they could award statutory damages or attorney's fees in the situation of a refused application. So I think that all of those really point to that this is serving a significant function for the court system, as well as, there's going to be one person, one side of the issue who's never going to agree with it.
I don't want to argue against self-interest in this particular case, but I would disagree a little bit with your statement that there's no litigation value to the registration process. It's not as valuable when the registration is filed right before the litigation, but with deposit copies, it's essential for the defendant, not just an infringer, but someone who's not an infringer who has been sued, to be able to get the deposit copy that was actually filed with the office, present it to the court, and say whether the plaintiff has somehow played some games there. There have been some cases where plaintiffs played games, although I take your point that under Rule 11, the attorney, if they know about it, is in big trouble. But there have been some cases where plaintiffs play games. Unfortunately, from time to time, the deposit copies get lost, which has been a big frustration, or it takes too long to get them. But it is a very effective method of defending a case, and I actually am probably the reverse of you. Although I do a lot of plaintiff side work, it's probably more like 75 defense, 25 plaintiff for me. And a lot of the cases I defend are for movie studios who are being sued, and someone claims, well, this stole my screenplay. But the screenplay is not always attached to the complaint. If we can get a certified copy from the Copyright Office fast enough, in a motion to dismiss, we can ask the court to take judicial notice of it, compare it to our movie, and then say there's no substantial similarity between the two works. And so there are values to being able to get those deposit copies. Sometimes it doesn't work out as quickly as I want it to, and sometimes they end up not being there anymore. But there is some good value there, in addition to some of the other things we just talked about.
It's also saved a few plaintiffs because there have been situations where the registration certificate doesn't match up, and this happens a lot in software, doesn't match up with precisely the work that's claimed, but the deposit, which courts look to as being what is the copyrighted issue, does. And so it has saved a few plaintiffs in that situation where it's the defendant comes in and says, well, but you're suing me for this other thing, not that thing, and it turns out that the thing that they infringed was what was on deposit. But other than that, I agree 100%.
With the application, you do have the deposit material, so you can, once if you have the application, so the registration, I'm talking about the registration, not being a prerequisite. You have the application, so you can get it for your review, and you can get it for your review. The application is there.
Yeah.
You don't necessarily attach it to the complaint, but immediate discovery or anything else, or formal discovery or formal, you get the deposit material.
I don't think anything I said weighs in favor of adopting the rule that the office action has to have taken place, because as you say, even if the application is still pending, the litigant can go to the office and request access by attesting that litigation is ongoing, and they can get that deposit material. Plus, in the case where it's not filed until right before the lawsuit, the plaintiff's a lot less likely to play games and file one thing and then sue you for something else. Whereas if they filed it 20 years ago, sometimes that happens. They've lost every original they have. They try to reconstruct the work, and then that doesn't come out till 6 months of discovery when you get them in the deposition chair, and they say, oh, well, yeah, this wasn't actually the exact original, but I could remember enough of the screenplay that I just rewrote it, and that's what's at issue in the case. So it doesn't weigh in favor of the respondent's position that there is value to that process, but I have found it valuable.
But under the application rule, you might find when you go for that discovery that the Copyright Office hasn't received the deposit yet. And how much would it cost the creator to go through discovery to find that out, as opposed to the registration rule and perhaps the $800? Would it be more than $800 to go through discovery phase of litigation?
Well, I mean, a good proactive lawyer would come to you and ask for those materials, whether the application is processed or not. And my understanding is I could still get that, even if it's not been processed, if I file a litigation statement and attest to you that I need the materials for defending the case. And so, yes, if I failed to do that and went through 6 months of discovery before I found out that there was no deposit copy, my client would be quite pissed off at me, but hopefully I won't make that mistake.
Do you do that for free?
We're going to have to wind up this masterclass in just a moment. Is there a last question? Please.
So just back to the who cares question, and because we're talking about congressional intent, do any of you have a sense of current members of Congress and whether people on the Hill are paying attention today and where they might come out on this debate? If you talk to folks.
I mean, it certainly plays into the discussion around Copyright Office modernization that's been going on for the last few years, in sort of all of its multiple permutations. There has been a push to modernize for some, what constitutes modernization is, everyone's got a kind of a different opinion about it. But the general consensus that the Copyright Office, particularly its IT infrastructure, needs to be brought up to date. And I think the case, definitely kind of underscores the delta between, what lawmakers or users would consider optimal and where we are in terms of processing time.
Yeah, I don't know whether any action is likely, but I think I would hope that if the respondent wins the case and the rule is that the registration certificate must have been issued, that the trend Rob is describing about Congress increasing appropriations for the office would continue in an even more robust manner so that the processing times can come down and some of the real concerns that people have become less of an issue. So that would be my hope, that if the court comes out in favor of the respondent, the Copyright Office and others could use that to explain to Congress why it's even more important after that decision that the office be well funded and that they have enough examiners and that processing times come down.
Can I also say that, I know this was mentioned earlier, for any students in the class, right, where this issue is going to play out, you'll get a front row seat if you join the CSUSA for $25. I think it's the best $25 that you will ever spend. I teach as an adjunct at Emory Law School, and it's a requirement that the students have to join. And by the way, if you have an extra 25 or even an extra 50, it's the same price of admission for students to AIPLA and for INTA. But I think there will be some movement, and I think that though CSUSA did not weigh in on this case, I think that they realize that their constituents on both sides are going to want to get a system that gets the Copyright Office fully funded and more, and really supports the creators amongst them. And it's going to be tough for either side, because one side's going to win and one side's going to lose. So.
What a wonderful note on which to close. Thank you all very much. Is there something outside? There's something outside, so maybe we can continue the conversation further.
Very nice to meet you. So, Terry Corp.
Yeah, he's right up there,
I'm so
actually.
interested
Oh,
in
okay.
what's to do from the people who know what's actually going on.
We've,
Do you know anything that would be very
I filed
interesting?
a petition last
Live mics.
out of the Ninth Circuit. Appreciate it. To Memphis. And I think my co-counsel Darren Quinn has been in touch. But very interested because we don't have a circuit split, so we're going to need a big swell of amicus. And
Yeah, it's an interesting case.
I think it's certainly aligns with your folks. And I'm not sure if you got my note, but your brief.
Yeah, I really appreciated that. So you've already got my contact information.
Well, it's putting a lot of faces to Twitter.
Yeah, it was nice.
Last couple of weeks between this and MagFest, which was last
Hopefully
week.
you're wrong about the
video.
Well, I don't, I'm always negative.
A lot of faces
Because
dancing together.
then if we win, it's a wonderful surprise.
Yeah. No, I'm glad you were here because I thought I would be the only pro petitioner on the panel. So.
Yeah, and somehow the invite and my response to it didn't
Not
circle
stand
around.
the heels of
I was happy.
and
Yeah, great to meet you.
Yes, same here.
it's 100.
How are you?
I really want
Oh, you were?
I'm admitted to
Very well written.
California doesn't issue.
Let's just step over here. I never like being on the post panel webcast.
So you have to specifically go request it from the California Supreme Court, which requires, in the year of our Lord 2019, that I send a self-addressed stamped envelope with
luck. Nice to
$5
meet
in
you.
cash or a checkbook, but I'm a millennial, so I don't have a checkbook. And then you just kind of wait for them to get around to it. So I'm actually.
I had not. No.
This is where I am in my life.
Yeah, I
Blank
think-
envelope and stamps.
He had to kind of
It's on me.
some basics,
Oh, absolutely.
kind of
Pick up on
explanation
that.
at the beginning, and he did a good job of that.
My moral character, there we go.
But I thought your colleague
those
did a
recreate meetings that
fantastic job as well. His presentation style was very, very entertaining and engaging and effective. I always think they're asleep, and then I realize they're not. They're just resting.
That was, I had
as
a
my daughter
Twitter
said.
exchange, actually with Terry, I think. And that was just a number, I couldn't actually find where it was sourced from, and we were searching for it in the brief. Right. Yeah, I don't know. That was just tossed at me on Twitter, and I was like, I don't know, that sounds reasonable-ish. But we weren't able to back it up with any actual sites anywhere, so we ended up not name-checking it.
I'll try to track this down. He'll box this down.
Oh, I know.
Corresponded with